Undue influence. Undue influence involves one person taking advantage of a position of power over another person. Examples of unfairly using influence include taking advantage of someone who has placed blind faith in an agent who has ulterior motives. Creating or causing a weakness of mind is another example of undue influence. After spending hours at the dealership, the sales agent was able to convince a buyer to purchase an expensive warranty for a car that the buyer did not want or need. Another example would be the salesperson who states that the good deal has a time limit that does not allow the buyer to consider alternatives. Mistakes. A contract may be canceled if both parties to a contract mistakenly interpret the terms of the contract or misunderstand the material facts. Given that the adverse outcome is the result of honest misinterpretation, the negative outcome resulting from the negative influence is not the result of deceit, concealment, or distortion of the truth. If mistaken because of the interpretation or meaning of a contract, it can be abandoned based on a mistakes ruling. If only one party is mistaken, the contract is not necessarily avoidable. It may only be canceled if the other party was aware of the mistake and did nothing to rectify it. In writing. As previously identified, the Statute of Frauds requires that most real estate contracts be written and signed by the buyer and the seller to be enforceable. The terms of contracts must be clearly stated with no ambiguity so that nothing is left open-ended or to be agreed on in the future. When ambiguity limits the meaning of a contract, courts will either refrain from interpreting the meaning and/or interpret the contract for the party who did not prepare the document. For instance, because an agent prepared the listing contract, it is interpreted for the passive party and against the broker. This means that questions as to whether the listing was an exclusive agency or an exclusive right to sell, the courts would construe it as an exclusive agency. Until a contract is signed by both parties, the terms remain negotiable. The contract becomes steadfast the moment the contract is signed. After signing, to modify terms, both parties are required to negotiate and accept new considerations. Note: because the property is the subject of real estate contracts, the agreement should contain a concise description of the property. That is, an assignment of lease, mortgage, or deed should include a copious legal description. Contracts for sale do not require a legal description, but should include such facts as address, size, and lot number. Contracts identified in the Statute of Frauds may not need to follow a specific format. As such, they can be written on a dinner napkin and still be legally enforceable, provided they include the following 6 specifications. Adequately identify the purpose of the contract, a concise description of the property, list the terms to be met by the parties, shows agreement between the parties, signed by both parties, indicate that by signing the contract, each party has committed themselves to the specified contract terms. Providing these details in a contract helps eliminate disagreements that could occur later in the transaction process. Consider the following case. Fawkes had known a real estate broker named Sec for a long time, so when Fawkes decided to sell his Sacramento ranch, he asked for Sec's assistance. In the process of establishing an agency relationship, Fawkes did not wish to have a formal listing agreement. He said, "You know darn well, you know me, I'm not going to cheat you out of a commission." Fawkes then initialed and dated the card 3/24/65 GWF Sec, later identified a buyer. However, Fawkes refused to pay him a commission. In court, Fawkes argued that the comments on the business card did not comply with the Statute of Frauds. However, the court ruled differently, adding that all Sec needed being written, signed memorandum showing the facts of employment. The note, 6% commission, with Fawkes initials, fulfilled this requirement. Sec v. Fawkes, 25 Cal. App. 3D 556, 102 Cal. RPTR 170, 1972. Although this is a California case, most states adhere to the law that a contract satisfies the Statute of Frauds as long as it includes the agreement between the parties and it is signed and/or initialed. In most states, the contract needs only be signed by the person being sued. However, including all 6 specifications listed above adds confidence that your contracts will not be revisited in a courtroom. Note: as a general rule, haphazardously written contracts risk enforceability. As the name Statute of Frauds suggests, the written requirement is meant to reduce the risks of fraudulent claims. If parties to an unwritten contract or a poorly written contract later disagree about contract terms, it could result in costly and time-consuming legal entanglements. Well, written contracts provide concrete evidence of the existence of an agreement and prevent otherwise unfair outcomes. Avoid using on or before in contracts. On or before is often included in contracts to show that performance may be completed prior to the deadline date. When submitting or accepting an offer, there are many scenarios in which it might seem prudent to insert this verbiage before the close of the escrow date. For example, a home has to sell before a new home can be purchased, or the parties are hoping for a quicker close of escrow than the designated close of escrow date. Regardless of the reason, do not do it. Inserting additional language into the contract, such as on or before, may have unintended consequences. Consider the following scenario. In order to purchase a new home, the buyers must sell their current home. The sale is scheduled to close escrow on August 3rd, 2016. Subsequently, the buyers submit an offer on a new home, requesting to close escrow on or before August 4th, 2016. The buyer's offer is accepted. As luck would have it, the buyers are able to close escrow on the sale of their home 1 week early. The buyers are now demanding the seller close the transaction before August 4th. Unfortunately, the seller cannot possibly be out of the house by then. The buyers are upset, and both parties have decided to consult legal counsel. The best outcome for the above scenario is that the parties are able to close escrow early. However, the worst-case scenario could involve a lawsuit with claims for breach of fiduciary duty against each party's agent. The outcome? Depends. In spite of the uncertainty of a lawsuit's outcome, you can be certain a lawsuit will cause anguish, take time away from your business, and cost money. Therefore, the best practice is to have a definitive close of escrow date so that the parties' expectations are managed accordingly. If the parties thereafter mutually agree to a different date, the parties can amend the contract.